Hi, everyone. Thank you for joining our Friday weekly Lunch and Learn. Every Friday at noon, Sierra Club Iowa chapter goes live to give you an important update about the environment. And this week we are going to talk about carbon pipelines. We haven't done that for a little while, and we have quite a few legal things pending that we're waiting on decisions for. So we thought it would be good to review what we are monitoring and what we've been asking for, and that way you can take action on any of this stuff. So I'll get to it here. Got lots of court updates. So the first thing is that Summit is trying to change the rules in the middle of the game. If you remember, throughout the last four legislative sessions, one of the biggest talking points we've heard from our opponents is, we can't pass a bill because we can't change the rules in the middle of the game. And well, now that's what Summit's doing. We've been fighting this pipeline for nearly 5 years. Our work and our cases are now in the courts at multiple levels on multiple issues. And now Summit's trying to change the rules, skirt the courts, and try to force their pipeline through. So just a reminder is that when we're talking about the Summit pipeline, there's technically two phases is what we call them. Back in 2021, Summit applied for their initial pipeline route, which is the blue line on the screen, and that's what we call phase one. That is the part of the project that has been around since 2021. They got a permit issued from the IUC. We've appealed it. And so it's been around for a while. Now, these pink lines are what we call phase two. After the Navigator pipeline canceled their project, Summit hooked up with some of those ethanol plants and expanded their initial route. So all of these pink lines are what we call phase two. And those are at the very beginning of the process. So they are far behind the route that is in blue. And that will just help you as we're talking about phase one and phase two cases. You'll know we're either talking about the original route, phase one, or we're talking about the expansion routes, which is phase two. So this will be a recap, but it's important to keep going over it until we get our answer. But the first thing is Summit made a motion to remand. And basically what this is when Summit was approved for its permit back in 2024, they were issued a conditional permit. And that was issued by the Iowa Utilities Commission. We did not agree with the issuing of their permit. So Sierra Club, landowners, counties, legislators, we all appealed that IUC decision in district court. One of the steps in the process is written arguments, and those were completed, and there was a record in the court of over 100,000 pages for the judge to review. So this is a big deal case. We've spent a lot of time building up to this point. We were supposed to have oral arguments on October 10th, and 2 weeks before oral arguments, Summit filed a motion to remand the case back to the Iowa Utilities Commission, essentially skirting the courts. They know that they have a more friendly decision maker with Iowa Utilities Commission than the district court judge, so they'd rather send the case back to the Iowa Utilities Commission. So on October 10th, instead of having oral arguments about the overall case and why the permit should have never been approved in the first place, we argued whether the case should stay in district court or go back to the IUC. And obviously, we think our case should remain in district court. We think we should move forward with all the work that we have done. And we are currently waiting on a decision from Judge Beatty on whether or not this will stay with the district court or whether it will go back to the Iowa Utilities Commission. So that's the first thing we're waiting on. But Summit's not stopping there. They're asking for a bunch of other changes as well. And the next one is their motion to amend. And this is regarding the Iowa Utilities Commission and their phase one conditional permit. So that permit that they received back in 2024 didn't just say, go ahead and you're approved, build the pipeline. It put conditions on it. And Summit cannot start construction of the pipeline until they meet all of those conditions. Two of those big conditions that are really important is that Summit cannot begin construction until they have approval in North and South Dakota. Well, we all know that last year, South Dakota banned eminent domain for carbon pipelines, and they've denied Summit's permit request twice. So as of right now, Summit can't really get through South Dakota unless they can find a route with all voluntary easements. So essentially, they have a permit that they cannot use. Summit is still a pipeline to nowhere. because their request to amend, they're trying to remove that North and South Dakota so they can, begin construction, but they're not telling us where they're going to go now instead. If they're not going through South and North Dakota, are they going through Nebraska? Are they going to go north up to Wyoming, Colorado, south down to Texas, Oklahoma? It doesn't say any of that. So this is still a pipeline to nowhere. We also don't know what is the CO2 going to be used for. So a lot of things will change if they're, asking to remove these conditions for North and South Dakota, indicating that they plan on going a different direction. We believe that the Iowa Utilities Commission should deny Summit's motion to amend. It makes no sense to approve a project that we do not have information about. And then there's this other big legal question: is since our case, this appeal case and docket is in the courts right now, does the Iowa Utilities Commission even have jurisdiction to change anything? So for many reasons, we are asking the Iowa Utilities Commission to deny Summit's motion to amend. Next thing that Summit is asking the Iowa Utilities Commission to do is consolidate their dockets. So a motion to consolidate. So anytime you want to build a pipeline or any sort of utility project, you open up a docket with the Utilities Commission, and then all of the public comments, all of the legal filings, everything gets shows up in that docket. On phase one, Summit had one docket, and so we had one group of landowners all impacted working on the same case. But when Summit decided to start the phase two, they wanted to make it harder for people. They wanted to make it so that every single little expansion was its own docket. That makes it harder for people to organize because, your docket may be at a different status than the others. Makes it hard to know who's who. Means that when you have to file something, you file it 15 times instead of just one time. So there were lots of reasons Summit did that. It was to make it harder on us. We and others made 2 requests throughout the process so far to consolidate all of these dockets into one to make it easier on the landowners, easier on the attorneys. We're following and monitoring one docket instead of 15. But Summit fought our requests and won. So we've been operating under the premise that these are separate dockets. But fast forward to now, they've changed their mind. And now that it's convenient for them, Summit wants to consolidate all of their phase 2 dockets in with the phase 1 case, which would essentially fast track and complicate the process for all of these newly impacted landowners. So Iowa Utilities Commission should deny Summit's motion to consolidate. They want these conditions of North and South Dakota when it's convenient for them. Then they want the conditions removed when it's convenient for them. They want all separate dockets when it's convenient for them, and then they want them consolidated when it's convenient for them. That's not how this works. Summit doesn't get to just change the rules in the middle of the game. So we're asking Iowa Utilities Commission to deny the motion to consolidate. And then Summit went at it again. They're still not done yet. In November, they asked the Iowa Utilities Commission to schedule a scheduling conference. And that would be for the phase 2 dockets. The scheduling conferences are when all of the parties, attorneys, landowners, and interested parties come to a meeting to discuss deadlines, hearing dates, and other logistical processes for the dockets. So there's no decisions made usually at those, that just everyone kind of weighs in on, here's what I think the hearing date should be, or things like that. There is no reason to hold a scheduling conference for a pipeline to nowhere that has very little support and has so many outstanding legal questions. We are not ready for a hearing schedule or a process schedule at this point. Now, when we were at the Iowa Utilities Commission meeting in November, they told us that they were going to be canceling the December public meeting because they're so busy in December. And now we are in December 12th. We still don't have a response from the Iowa Utilities Commission. So we are assuming that there is not going to be a scheduling conference before the holidays. Summit is just trying to fast track this, make it difficult. And, I think the Iowa Utilities Commission is not going to try to move that quickly for Summit's request. All right, next thing. So not talking about the Iowa Utilities Commission specifically or the district court. The other thing is that we're also on our way to the U.S. Supreme Court. And this goes back to counties. Throughout the whole process, starting 4 years ago, many counties started passing zoning ordinances with setback distances for how far is the pipeline away from people's homes or schools or businesses, city limits, things like that. Summit was not happy about these zoning ordinances, and so they decided to sue a bunch of the counties that passed these ordinances, trying to take away their local control, essentially. So two counties, Shelby and Story, are taking the lead and taking this case all the way to the U.S. Supreme Court to hopefully win local control on zoning ordinances for carbon pipelines. The most recent update is that ISAC, which is the Iowa State Association of Counties, they represent all of the counties in Iowa. They filed an amicus brief on November 6th on behalf of all of the counties in Iowa to increase the chance that the U.S. Supreme Court takes up our case. So the U.S. Supreme Court will get lots and lots of requests to take up cases every year, and they only pick so many to do. So we have to do our best to make sure that this is highlighted in front of the Supreme Court and they take up this case. ISAC also asked counties to support this amicus brief with a $500 donation and also with just, verbal support that we support this amicus brief. And you can see a map on the screen here. The counties in red support the amicus brief. They voted yes to donate $500 or more dollars. The blue counties have it on the agenda, and we need to follow up to see how those votes went. Shelby and Story counties are the lead counties, so they're not able to sign on to the amicus brief. And we had a few counties vote no, but we're working to flip those votes as well. It's not too late to tell your county to support the amicus brief. So if you think that your county should be doing that and they're not red already, feel free to contact your supervisors and have them get a hold of ISAC to go through the process to support it. The next thing for this request to go to the U.S. Supreme Court is that Summit has to file a response to the legal petition. They have an upcoming deadline, and so we're waiting to see what Summit says, and then we'll kind of be waiting to see what happens next with the U.S. Supreme Court and if our case gets picked up. So we'll keep you updated on that. All right, and now this is an exciting one. We actually have an outcome of one of our many legal cases, and this is up in North Dakota. In 2023, a landowner group in North Dakota sued the state of North Dakota and the State Industrial Commission. And they were claiming that the state law that requires landowners to allow CO2 storage beneath their property, if at least 60% of the affected landowners agree, is unconstitutional. So it's basically the area where they're planning on putting the CO2 underground. It's kind of like eminent domain of your pore space. If 60% or more of the affected landowners in that geographic area say yes, the others, they have to participate as well, because how do you make sure that the CO2 doesn't stay on someone's land and not someone else's land? So they're claiming that that law is unconstitutional. A district court judge found that North Dakota law related to underground storage of CO2 is unconstitutional because it allows a government authorized taking of property without an avenue for just compensation determined by a jury, which is a huge deal. So the landowner's attorney believes that this decision voids all orders issued by the Industrial Commission, which essentially, tells us even more that Summit is a pipeline to nowhere. Now, Summit could appeal this, so we will keep you updated if Summit does appeal. But as of right now, we got to celebrate these victories and spread them far and wide. So thank you to North Dakota landowners for keeping up the fight up there. So what's next as we're waiting for all of the decisions on all of these court cases and legal requests is the legislative session. It's starting in less than a month, or I guess about a month from now. And so it's time to start contacting our senators and representatives and asking them to stop eminent domain for carbon pipelines. That is the one solution that's going to address all of the issues that people are facing right now, whether they're worried about safety or whether they're worried about the land destruction or the water usage. If we can stop eminent domain for carbon pipelines, we can solve a lot of our problems. So we need to contact our legislators, let them know how Summit's been behaving and that they don't deserve to be protected anymore. It's time to pass the bill. We need to get it through the House, through the Senate, and onto the governor's desk for a signature. So you can contact your legislators by visiting legis.iowa.gov legislators/find. And I will put that here in the comments in just a minute. So that way it makes it easy for you to just click on it and contact your legislators. And if you have time, feel free to contact all of the legislators. That is always helpful if you have the extra time. So thank you, everyone. We appreciate you tuning in. And if you have any questions, please put those in the comments and we'll answer those later. So have a great day and we'll see you next week.